Hello, and thank you for joining us. My name is Katie Perez, and I'm a senior associate at Scott Legal PC. Today, we are going to spend some time talking about the E-2 visa requirements and renewal considerations. But just a few things before we get started. Some of you may know that the firm was founded on an E-2 visa several years ago. Our founder, Ian Scott, is in the US on an E-2 visa and has been on several different visas, including an F1, ATN, a B, and H-1B. Scott Legal PC is a full-service immigration law firm, and we offer immigration services in several different areas, including E-2, E-1, TN, L-1, family immigration, national interest waivers, EB-5, extraordinary ability visas, and more. We have processed hundreds of E-2 visas, and we typically process E-2 visas that are higher risk, meaning they have lower investment amounts. We have processed at consulates around the world, but primarily we process in Toronto and London. We will continue this webinar series doing at least 2 webinars a week on different topics. At the end of this webinar, we will send out several useful tools. We will send you a copy of the PowerPoint presentation from today, a link where you can download guides that go through the visa options in more detail, and also a link where you can sign up for additional webinars. This webinar will be recorded and will be available on YouTube. We will also send the link for that. We encourage you to subscribe and hit the notification button as we regularly upload immigration videos on a wide variety of topics. We will also send a link where you can arrange a consultation with one of our experienced immigration attorneys if you would like to discuss your case in more detail. If you have any questions throughout the presentation, please put them in the chat box and we will address them at the end of the presentation. Today, we are lucky to have Kelly Weiner present the webinar for us. Kelly is a partner with Scott Legal PC and has extensive experience processing E-2 visas. So without further delay, let us get started with the webinar.
Thank you, Katie. All right, so we're going to talk today about the E-2 visa requirements and also considerations for renewal. So to get started, we will talk a little bit about the E-2 visa requirements. So one major requirement is that you have to be a national of a treaty country. And so this means that, the specific country has a treaty with the United States that allows for the E-2 visa and then generally a reciprocal visa, for U.S. citizens. And there are over 80 E-2 countries. So the list does change. Countries are added. Sometimes countries are taken off. So it is important to kind of double check the list to make sure the country is still on there. Countries that were added in, the last 10 years include Israel and New Zealand. I think Iran was taken off. So again, always good to check. The E-2 company has to be owned at least 50% by treaty country nationals. And if you're an E-2 investor, you have to own at least 50% and be coming to develop and direct the E-2 business. So the E-2 is not for somebody who wants to kind of retire to the United States and just kind of buy a business but be a passive owner. You actually do have to take a hand in developing and directing, the company. You have to make a substantial investment, and your funds must be at risk and irrevocably committed. This means that if you are, starting up a new business, you actually have to spend money. You cannot just place cash into a business bank account. It must be at risk in the commercial sense. So you must have spent it on things that are necessary to get the business up and running. Or if you're purchasing a business, you have to have transferred the money to the seller or to escrow. How much investment is enough? We'll talk about this in later in the presentation on additional slides. There is no specific dollar figure in the regulations. So for visas like a green card, like the EB-5 green card, there's a specific dollar amount that has to be invested. That's not the case for the E-2. What is substantial is going to depend on the type of business you're starting and the proportion of your investment related to that total startup cost. You do have to show that the money that you're investing comes from a legitimate source. This can also be a gift given to you or a loan, as long as it is a personal loan secured by your own assets or an unsecured loan. But it does have to be proven to come from a legitimate source. So even if you are getting a gift from someone, they need to be able to document where they got the money to give you that gift to prove that it's a legitimate source. The business has to be real and operating. So if you're purchasing an existing business, you're going to show things like, tax returns, business bank statements, invoices, reviews, depending on what type of business you have, just showing that it's operating. If you're starting up a new business, then these are going to be things like you've gotten a federal, tax ID number for the business. You've set up the business bank account. You've gotten office space for the business. So this will, what you're going to prove here for real and operating is going to depend on what type of business you have. Another requirement is marginality. So the business has to support more than just the investor and their family. And what this translates to is you have to hire workers in the United States if you want to get an E-2 visa. So the E-2 visa is kind of not for someone who wants to just come in and operate as a solo consultant. You do actually have to show the business is going to support more than just you, and your family. Also, you have to have the intent to return to your home country if the E-2 status ends. So there are some visas like the H-1B and the L that have explicit allowance for dual intent, meaning you can apply for a green card while on that visa and there's no inconsistency. For the E-2, this is technically a visa that requires this intent to depart. However, the standard I would say is somewhat lower than other visa types. So you don't have to have a residence in your home country that you can prove that you're not going to have to abandon. The regulations say you can move your entire residence to the United States and you can renew the E-2 indefinitely, but you have to maintain that temporary intent and that intent to depart. All right, let's talk about options and timing for obtaining an E-2 visa. So there are kind of two major ways to get an E-2 visa. One is you're going to start up a new business in the United States, and the other is that you're going to purchase an existing business in the United States. So if you're starting up a new business, you're kind of doing everything from scratch, incorporating a company, getting a business bank account, funding it, making the investment, getting the marketing in place, everything you need to start running. If you're purchasing an existing business, you have kind of a benefit here in terms of protecting your investment. While for a startup, you're actually going to have to spend that money and put that money at risk. In a, purchase sale scenario, what you can do if the seller agrees to it is you can execute the purchase sale agreement, but then rather than transferring the money directly to the seller, it gets transferred to an independent escrow agent. And there's an instruction that says if the sole condition for this, that this purchase to go through is going to be the approval or denial of the E-2 visa. If the E-2 visa is approved, the money should be transferred, to the seller. If the E-2 visa is not approved, then the money will go back to the buyer. So if you're purchasing a business for an E-2, you do not have to use escrow, but you do have the option to use escrow, and you can still successfully argue, that the money is at risk because the only condition for release of the funds to the seller is the approval of that E-2 visa. Um, so how long is your E-2 visa valid for? So this is going to depend on your country of nationality. There are different kind of reciprocal agreements between the United States and various countries. And so the length of time the visa can be granted for sometimes will change depending on how much time the other country grants to U.S. citizens. So for example, France, that's like one where the E-2 visa length has changed several times over the past few years, where at one point it was 5 years, at another point it was 25 months, at another point it was 48 months. So you do want to check kind of the reciprocity agreements to see how long can you get your visa for. Many countries, the visa can be issued for 5 years, such as, Canada, the UK. Others it can be issued for, sometime only for 3 months. For example, Egypt and Bangladesh, you can only get a visa valid for 3 months whether or not, whatever the visa is valid for 5 years or the visa is valid for 3 months, when you enter the US, you can be given 2 years E-2 status. So even if your visa is only valid for 3 months, the visa is just that entry document. Once you enter the US, you're given a status, and that's what tells you how long you can stay in the United States. And so if you enter on that 3-month visa, you can be granted 2 years in E-2 status. And that means you can stay in the United States for up to 2 years running that business until your I-94 expires. Once you do leave the United States, let's say you leave earlier than 2 years, you will have to go back to a consulate and get a new valid visa, before you can re-enter. We also have listed here consular officer decision. That's just to say there is an ability for the consular officer to limit the amount of time your visa is granted. So even though your country may say, well, you can be granted a 5-year visa, if the officer decides, well, I'm a little worried about this business, they might choose to only grant your visa for 2 years or 3 years. They cannot grant it for longer than the reciprocity agreements allow, but they do have that discretion to grant it for less time, if they choose. All right, let's talk about how much investment is enough. This is a very common question, and there is no minimum set investment amount. So the regulations say you need to invest a substantial amount, and the amount you have to invest is going to depend on the type of business, where you apply, and what type of examiner you get, and the overall strength of your case. So the way that the law works is they will, they've written out in the regulations a proportionality test. So this is what the consular officer is considering when they look at your investment, which is what are the total costs to get this type of business up and running, and then especially if it's a smaller investment amount, like say any investment under, $250,000, have you invested 100% of the cost to get this business up and running? So when there's a lower investment, like let's say $100,000, they want to see you've invested 100% of the costs to get this certain type of business up and running. Let's say for a service-based business, like a consulting business, a property management business, anything kind of service-based where arguably you don't need a lot of capital to get started. You want to be able to say you've invested 100% of the cost to get the business up and running. And you can try to define that by including market research reports, industry reports, things that talk about, what are the normal startup costs for this type of business. If you have a business that has an extremely large startup costs, like let's say you're doing kind of car manufacturing on a large scale and, investments are, hundreds of millions of dollars and you've invested 10 million, you might still be able to get the E-2 based on the magnitude of your investment. So kind of if you have an extremely large investment, which is obviously much more rare, and you've only invested a small percentage of that, you still may be able to get approved if it's something of the magnitude of 10 million or something like that. That being said, for most investors, they're investing a much lower amount, and so they want to be able to show they've invested a much higher percentage of the startup costs. When you are purchasing a business, the way that they'll look at this is what is the purchase price, and that will generally be considered the fair market value of the business if it's an arm's length transaction and you found this business kind of on the open market. If it is a situation where you're purchasing from a friend or a family member, maybe a good idea to get a valuation done, maybe have a CPA assess kind of the financials and write a letter explaining how you came to the purchase price. For example, if the tax returns, and financial statements are showing, very profitable business, high amount of assets, a lot of cash in the business, and the purchase price for 50% of that business is very low and it's your brother, they may look at that, and have some questions about whether that's really the fair market value. So these are things to consider when you're looking at the E-2. Franchises are a good option for E-2 visas, either purchasing kind of an existing business and taking over a franchise agreement, or kind of starting up your own business and signing a new, kind of franchise license agreement, when you get started. It can be helpful just to show that there is an established business model and ability to have success there. You do want to watch out for franchises that, some kind of won't permit, people who are not U.S. citizens or legal permanent residents to own a majority share of that business. You want to watch out for that. And also just for any franchises where it doesn't feel like the owner really has any control or ability to develop and direct the business. Um, Common good and bad, E-2 visa expenditures. So not every expenditure is kind of viewed equally, by the consulates. For example, some of them even have on their website, don't include kind of flights, meals, taxis. They don't want to see kind of those type of expenses. They don't view them as very strong expenses. Common kind of good expenditures would be anything that is clearly related to kind of setting up your company. So things like buying computer equipment, getting, payroll set up, getting, business insurance, paying for any employees that you have, getting, commercial office space, furniture or equipment for that commercial office space, software that you need. You want to think about what is the type of business you're starting. So if you have a business that requires a warehouse, if you have a business that requires inventory, these are things that you would want to have that are good expenditures. as opposed to those expenditures like flights, for visiting the US or for taking out a client. Another thing that's not a great E2 expenditure is, let's say you own a company abroad and you also have a company in the United States. Having your company in the United States pay your company abroad that you own for setting up a website, that's not necessarily going to be viewed very strongly. They may not think that your money is really at risk there, but you're just transferring it to your own related company. So these are all good things to keep in mind. All right. So do I have to hire U.S. employees? And the answer is yes. So the E2 business has to have either the present or future capacity to generate enough income to provide more than a minimal living for the investor and their family. What this means is they want you to hire workers, and they want you to hire workers in the United States. Generally, for a startup, you're going to have, we'll talk about this a little bit later, a business plan that shows you are going to be able to realistically hire those workers in the next five years. We usually recommend showing that you're going to hire at least 3 to 5 full-time employees over 5 years. If it's a little bit more, that's great. If it's less, it doesn't mean you can't get renewed. We'll talk about that more later, but it's kind of a good benchmark to have in mind. People will often ask, do I have to have W-2 employees? Can't I just pay contractors? So W-2 employees are definitely going to be stronger for your case. There's many consulates where, for example, on renewal for a startup, they just want to see kind of tax returns and W-2. So if you don't have those, you're in a situation where you're having to explain why you don't have those and why you should still qualify. That's to say W-2 employees are definitely much stronger than just having 1099 workers. There are certain industries, for example, like the construction industry, where it's just very common to have contractors. And maybe if you have a staff, a small staff, maybe you have 2 full-time people and they manage all your subcontractors and you're paying hundreds of thousands of dollars to subcontractors. In that type of case, often you can make a compelling argument that, the amount you're paying to the subcontractors is so substantial that it really is making that significant, economic impact in the United States. But it is risky to just rely on 1099 workers. And if you're in a situation where you're paying 1099 workers and you're not paying them very much and you don't have employees, that's going to be kind of the weakest situation where you're trying to argue for that. Um, how do you prove that you're going to hire these workers? So, and we'll talk about this more on the next slide, but if you have a new business, you're going to need a comprehensive 5-year business plan. Letters of intent, are also very helpful, both to show that you're going to hire people, but also just to show you're going to have enough business that you will need to hire employees and also be able to pay those employees. If you are purchasing an existing business, you want to be able to show W-2s. You want to be able to show pay stubs, tax return showing wages paid. If you are purchasing a business and they say, well, yes, we do have employees, but we pay them all off the books, this is not a good business to purchase for an E2. You want to make sure that when you're purchasing a business with an E2 in mind, that you can show that historically this business has hired, W-2 workers. If you purchase a business and it has not historically hired W-2 workers, then that's a case where you'd want to include a business plan and explain how you're going to expand the business and kind of turn things around and be able to hire workers in the future. All right, so what should the business plan contain? So as mentioned previously, the business plan is a very important part of the E2 application for kind of new startup, E2 applications. So you want to have this executive summary, who are you, what do you do, who do you sell to, have that market analysis and research to show, yes, we do have people interested in this type of business. Here's who our competitors are. This is something that will actually have customers or clients. You want to have that marketing plan. You want to explain, here's how we're going to get clients, particularly if you're in a saturated market, right? Let's say you're doing a consulting business. They want to know, why are people going to hire you? What is your plan for actually getting, clients and getting revenue? So you want to have kind of a robust marketing plan that makes sense. Most businesses are going to need a website. All of these are kind of important things to have in the business plan. Also a personnel plan. So we've just talked about, employees are a very important part of the E2 application. For a startup, you do not have to have employees before you file. It's helpful. It certainly makes your case stronger, but it's not a requirement. But you do want to have that kind of 5 years of, hiring projections, showing kind of job titles, job duties, what are the salaries, why is this reasonable in the overall financial picture of the company. Additionally, you want to have that comprehensive, financial plan. So 5 years of financial projections, a balance sheet, an income statement, a cash flow statement, and a common sense explanation of how the business is going to make money. Very often, the officer is going to be skimming this business plan. So you want to be concise. You want to be clear. The officer, from reading that executive summary, should understand, what does your business do. You want it, you want it to just be kind of very, drafted for the layperson, not kind of very technical, language. Or if you have that in there, you want it explained. But just knowing this person is going to be skimming this, and does this make sense, overall when I look at my business plan? Okay, let's talk about some E-2 visa considerations that come up a lot. So one is, should I apply for a change of status with U.S. Citizenship and Immigration Services, or should I go to a consulate? U.S. Citizenship and Immigration Services, definitely some pros and cons there. If you are going for this route, you have to already be in the United States in a status that allows you to change your status. So let's say you've entered on ESTA, maybe to do some investigation of your E-2. You're not going to be able to file with USCIS. That's not an option for you because ESTA does not permit you to change status in the United States. But let's say you're here on an H-1B and you're interested in starting up your own business, and you don't really want to go to a consulate because it's just more convenient for you to stay in the United States, then USCIS may be a good option for you. The real downside of filing with USCIS is what you're going to get is a 2-year approval notice that allows you to stay in the US and run the company. It does not give you the ability to travel internationally. And the approval does not mean that a consulate will rubber stamp your E-2 application either. So if you do get an approval for a change of status and then you need to leave for some reason, let's say 1 year in, now you have to go to a consulate and you have to apply for an E-2 visa there, and you have to submit a brand new application. The consulate does not have to take into account the fact that USCIS approved your E-2 visa. So there's certain visas like the H-1B or the L where you might get an approval from USCIS ahead of time. And when you go to the consulate, they're not re-adjudicating the substance. They're testing for other things like admissibility, but you're already approved for the H or the L. That's not the case for the E-2. For the E-2, you would be in a situation if you had to travel where you'd have to go to a consulate and submit a brand new application. This is to say that for people that need to travel a lot, USCIS may not be a good option. So another kind of a couple things to consider with USCIS. One is that they are more receptive to low investment amounts than consulates are generally. So if you have kind of a service-based company and it's, arguably could be started with very little investment, we've sometimes even had investments approved with as little as, $30,000 or $40,000. Those are obviously more difficult cases to get approved, but USCIS is more receptive to those than consulates. That being said, USCIS takes a very, very strict approach to the source and trail of funds. So let's say if you have, 4 sources of funds from different people with complex trails, that's not going to be a good case for a change of status. Because you will have to trace all that money, even if, let's say, it was from an inheritance many, many years ago. They're going to want to see the trail through all of those funds and the maintenance of those funds up until the funds were, given to you, and you then, use them to pay for E-2 expenditures. So let's move to talk about the consulates. For a consular filing for E-2, a benefit for many people is they can get a multi-year visa stamp in their passport that allows them, to come in and out and, develop and direct the business sometimes for up to 2 years. I'm sorry, up to 5 years. So that's a huge benefit for many people, that's going to be a better option for them. If you can get a 4-year, 5-year visa, often you will want to do that as opposed to going for a change of status. Besides the ability to kind of travel more freely, also consulates tend to take a more holistic view of the source and trail of funds. So if you're saying it's personal savings from employment, you're likely to be able to provide kind of your tax returns, proof of you transferring the money into your business bank account and spending it. Whereas USCIS would want to see you maintaining that money maybe even over years. So it can be kind of source of funds and trail of funds can be less complex for consular filings. For a consulate, you also have, kind of the ability to go to an interview and kind of answer questions and kind of make your case for your business, in person. So let's talk about source and trail of funds. So again, for USCIS filings, this can be very, very complex. They are not going to be satisfied with just kind of a holistic, kind of description of what you've been doing. They actually will want to see if it came from a sale of property. They want to see the purchase sale agreement. They want to see the money entering your bank account. Let's say that the property was sold 4 years ago. They want to know, where has the money been for those 4 years? Where did it go to? Where was it maintained? And you're going to have to trace all of that to get to the ultimate endpoint. So the source and trail of funds is something you want to consider. Ideally, you will have talked to an attorney before you transfer any of your money. Better to do that than find out later, well, my mom had this, 50,000 under her bed for a year, and now that's been transferred to you, and now you have no real way to trace that. So you want to just discuss that with your attorney ahead of time before transferring or spending any money if you can. Loans secured by assets of the E-2 company cannot be considered as part of your E-2 investment. So this comes up a lot in kind of seller financing situations. Let's say that you're purchasing a business and you're going to put down, 50% of the purchase price, and then 50% is going to be seller financing secured by the E-2 company. That's really not going to work well for an E-2 case. They're going to consider that you've only spent 50% of the money because the rest of it is secured by the E-2 company. So again, you want to talk to your attorney before getting any of that financing fully settled and in place. Gifts can be, part of the source of funds, but you have to have a gift giver who is comfortable sharing their sensitive financial documentation because you can't just include a gift letter and no other information. The gift letter has to be accompanied by proof of where the gift giver got the money. So if it's their savings from employment, that's going to be their tax returns. So they need to be willing to share that sensitive financial information. When you're having a small investment amount, so again, like anything kind of under, 250,000, you want to just think about making all other parts of the case as strong as possible. And some things that can make it stronger, for example, letters of intent. So this is saying, yes, the investment may be on the smaller side, but we're going to have immediate cash flow because we already have people that want to work with us. Letters of intent or contracts can be very compelling. You can also potentially have a CPA, review your business plan, review your investment schedule, ideally a CPA that works in your industry with small and mid-sized businesses, and maybe write a letter opining about the reasonableness of the investment and the fact that it would be, substantial and, able to kind of start this type of business. Um, E-2s for two investors. People will often ask, can I, do this with a business partner? The answer is yes. You can get two E-2 visas, two investor E-2 visas, as long as you own the business 50-50. If it's a different structure than that, then you generally wouldn't be able to get two E-2 investor visas. But let's say it's two Canadian nationals, they want to own it, 80-20. The 20% owner could be an E-2 employee. If you don't have the same nationality, that's not going to work. Then it would have to be 50-50. Substantive changes to the business after filing. So sometimes people will get a 5-year visa or a 2-year visa, and they think, great, I'm authorized to work in the United States. And it's definitely more restrictive than that. When you get your E-2 visa, what happens is you are being authorized to work at the company that you have presented to USCIS or to the consulate. If there are kind of changes to that business that are very substantial, then you would need to get an approval before making those changes. So let's say that you got approved for an E-2 for a wedding photography business, and now you want to close that down and start a restaurant. You cannot just close down the business and start a restaurant without getting a prior approval. However, you can also, plan for changes in your business to try to avoid having to go back. So let's say that you have an IT software services consulting company, but you want to do mobile app development in the future. In your business plan, you can contemplate, we're going to do software service consulting, but we're also going to have mobile app development, in year 3 or 4. This means that, if in year 3 or 4, that really starts to take off and you're still doing both, but more mobile app development, arguably you don't need to go back to the, consulate or USCIS because you've already contemplated this. They're aware of this plan and it's kind of aligned with the business you're doing. But really important to keep in mind any major changes to ownership, any major changes to the type of services you're offering, you should discuss with your attorney before making those changes to ensure you're not violating your status. And you should not shut down your business and continue to stay in the United States, just on the basis of the I-94, because the ability to stay is based on you continuing to actually develop and direct the business. Um, so for higher risk cases, these are, kind of when you're going into your interview or you're submitting to USCIS, you kind of know they're going to look at these a little bit more closely. One is real estate. So there's, over the years been some misconceptions that you can just kind of purchase a property, put it in the name of an LLC and collect, rental income. This is not going to be kind of considered a real and operating business that has enough activity to hire people. So if you're doing a real estate business, you just want to make sure that you're showing this is going to be real and operating. We are going to have clients, it's not just kind of passive, home, real estate ownership. Similar concerns with equity trading. They want to know you're not just kind of trading for yourself or maybe, limited for friends and family. They want to make sure that you actually are, establishing a business that's going to hire workers in the US and have significant kind of revenue and economic contribution. Family business purchases. So I talked about this previously before, but just again to know if you're going in and you're purchasing a business from a family member, they are going to ask you questions about that. You do want to have some explanation for how you arrived at the purchase price for this business, and it should align with the financials of the business. Okay, let's move to some common reasons for E-2 denials. So one would be low investment amount. There are strategies you can use with lower investment amounts. We have a webinar that kind of explicitly covers those strategies, but there are some investment amounts that are just too low. A client comes to mind who had spent $2,000 and put $98,000 in a business bank account. That's just too low to convince the officer that this person is really going to develop and direct the business and is really committed to it in a financial sense. So you do, if you are denied for a low investment amount, one potential benefit is if you do have more money to invest or you have working capital you haven't spent, this is something where you can actually kind of go back, spend more strategically, ideally on things that you need or would need in the next few years, and then go back and reapply and show that, you spent more. In the example I gave with that client with $98,000 in cash and 2,000 spent, this person came to us after they were denied. We were able to advise them on spending more. They ended up spending around 50,000 and were ultimately approved with a total investment amount of around 100,000 with 50,000 spent. The nature of the business can be a reason. So we just talked about it. There's some businesses that have higher, scrutiny on them. So, you may want to consider staying away from those areas unless you're really passionate about it or really feel like you could make that, a viable case. Filing location and venue. These are, always important to take into consideration. As I said, if you have a very complex source and trail of funds, USCIS is not going to be a good option for you. If you have an extremely low investment amount, there's going to be certain consulates where we just know they're not very friendly to those investment amounts because they're used to seeing large multinational companies and not kind of smaller investors. It is the case that you can't just kind of pick any consulate. Generally you do need to go to a consulate either where you're residing in that country or a legal resident there, or where you're a national of that country, you have a passport there. So, but it is important to talk to your attorney to understand what are the trends, in my venues, the venues where I have options at this point in time, and how does that change, the viability of my case. Um, the next two issues are kind of related. So just, are you going to create jobs for US workers? So let's say you have had a business in your home country for many years, 10 years, and you've been a solo consultant, and now you're coming to the US and you say you're going to hire people. They may not believe you on the basis of just a business plan because you have a 10-year history showing you didn't hire anybody. So in those types of cases, it really can be beneficial to hire somebody before you file, just to help, address that concern up front. Issues with the adjudicating officer. So when you do go for your interview, officers are human beings. They have different levels of experience and training. There are some that take a really, particular view of certain types of, cases. There's consulates where the consular chief or the guidance that they're getting, kind of will focus more on certain things or say any investment under this amount, shouldn't qualify, even though that's not what's in the law or regulation. So if you do feel like you had an issue with the officer and they really, were not correct in the law, there's kind of some very limited mechanisms you can try to undertake. The best one or the fastest one usually is to just reapply. Most consulates will try to give you a different officer, and you can try to explain in your new application, what the changed circumstances are and or why you think, the law was wrongly applied, last time around. Another reason might be you didn't meet the requirements at the time of filing. Sometimes people will file on their own or with attorneys that don't understand the requirements, and maybe the entire investment is secured by the assets of the E2 company, or treaty country nationals don't own 50% of the company. In those instances, all you could really do is, kind of reapply after you've, fixed that issue. All right, so let's talk a little bit about E-2 renewals. So what does it take to renew an E-2 visa? So one is going to be hiring U.S. workers. So if you've purchased an existing business and it has, 10 employees and you sustain those 10 employees, that's going to be fine. But if you are, applying with a pure startup and you don't have any employees at the time you file and you're going back, 2 years, 3, 4, 5 years later, they will want to see that you've hired workers in the United States. We generally recommend 3 to 5 full-time workers. Again, though, like let's say you had 2 workers in year one, and then that went down to 1 employee, and then you hired 2 more people, and maybe over the years you've hired, 8 people, but right now you only have one and a half. These are still things that you can point out to show that you have made good faith efforts to hire. This came up a lot, especially during the pandemic. Obviously, kind of staffing structures had to change, but you do just want to be able to show, kind of when you're going for your renewal, that you do have W-2s over the years, that you have tried to hire people. If you're in a situation where you have a low number of employees, maybe you have job postings out, so these are all going to be important things to put into the renewal application. They'll also want to see updated financial data. So many consulates ask for the last 2 years of tax returns. Some, like the UK, ask for kind of all the tax returns since you last, submitted. So that could be even 5 or 6 years. They're going to want to know, is the company profitable? If it's not profitable, kind of, what is the financial plan? Has there been additional investment from the investor? If so, you can show that. If the company has continued to be profitable without additional investment, you can point that out. Also kind of payroll information. So let's say you had a really slow start, you weren't able to hire anybody until this year. You should still include their payroll information and kind of show, what steps you took over the years to try to hire people. Um, Sometimes you can even include kind of a mini, business plan saying kind of here's our, our plan for kind of turning things around. Also important to show the company still meets the E-2 requirements. So this is where, if you changed the ownership, your US citizen business partner now owns 70% and you own 30%. That's going to, and you haven't kind of talked to an attorney, that's going to be an issue on renewal. You still need to show that you, hold the proper percentage of ownership in the company and have the ability, to develop and direct the company and have that control. Similarly, changes to the type of business. So, if there's been a major departure from what you initially submitted, and you haven't gone back and gotten an approval for that, that could be problematic at this point in time. Although, as I discussed previously, kind of natural outgrowths to the business or things that were contemplated in the initial business plan, those are not going to be, major issues. Okay, let's look at some developments and adjudication trends. So E-2 visas generally do have high approval rates. 80 to 90% is posted by the government, and that has generally been consistent, over the past, several years, even as the government has changed, administrations, over time. Something to consider is that you want to make more of your investments in the United States. It's not a requirement in the law, but it does help your case. And officers are likely to continue to ask, how much investment did you make in the US? Because the purpose of the E-2 visa is to facilitate that kind of economic benefit, between the two treaty countries. And so anything that you can do to show, like, yes, my business is having a positive economic impact on the United States, including making investment expenditures there, that's going to be positive for your case. Government may also want to see higher investment amounts. So, whereas many years ago, we may sometimes have gotten cases approved with, 50,000 invested and 15,000 spent. That's getting more difficult across the board. So you want to be thinking about making those, higher investments if you can. Hiring U.S. citizens will always be important. When you fill out your forms, there is a carve out that says, are you hiring U.S. citizens and legal permanent residents? Are you hiring other E, H, or L workers? Are you hiring third country nationals? They do look at that information. It's relevant to your case. Buy American, Hire American was an executive order from kind of, 2017, from kind of the first time, that the Trump administration was in power. And this is something that they focused on a lot. And so something that we do anticipate will continue to be the case over the next few years. You want to focus on employees rather than contractors. So as I discussed previously, W-2 employees are, stronger for your case, stronger for showing you meet the marginality requirement, than 1099 contractors are. That being said, if you're, paying vast amounts to contractors, that's something that can be discussed and possibly good for your case. We are seeing increases in administrative processing. There was an executive order issued earlier this year talking about enhanced vetting for all visa applicants. This does mean that, as part of enhanced vetting, they are looking more closely into everybody's background. There's additional background checks. What this means is that when you go for your visa interview, normally you're told right then and there, yes, your visa is granted or not. It may be the case that they say we can't deny or grant the visa yet. Your case is in administrative processing. And at that point, all you can do is kind of continue to follow up periodically with the consulate until, they've cleared your case to go ahead one way or the other. More USCIS filings. So I think there are, ever since the pandemic, this has kind of been the case where people are, more reluctant to leave the country or perhaps can't leave the country or there's difficulty in leaving the country. This does lead to kind of more USCIS filings. So as I discussed earlier in the presentation, there can be benefits to that, right? Like they are more receptive to lower investment amounts, but also downsides like you can't travel internationally, unless you go get a visa stamp. And as well, they will look more closely at your source and trail of funds. We are anticipating longer waits at consulates. There have been some significant policy changes this year. For example, interview waiver kind of policies really changed a lot, whereas previously there had been very permissive interview waiver policies, kind of, starting primarily during COVID. They've really tightened up on that and even gone so far as to say that, long-standing interview waivers for very young applicants or very old applicants, those are gone now as well. This means there'll be less appointment availability generally across the board, also hiring changes. All this kind of translates to, wanting to plan more in advance because consulates will likely have to take more time to get to your, your interviews because they're having to interview more people generally. All right, so we've reached the end of the presentation. And someone has indicated they did not see the slides. So we do see the slides and they will be available on YouTube when we share this presentation. So if there's no other questions, which it doesn't appear there are, I think we will close here. Thank you. Have a nice day.